Good morning. I'm just going to wait a few moments so that everyone can make it into our virtual room here. All right, it looks like we've all made it in. So I'm going to go ahead and get started. Good morning. I am Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. It is June 30th, 2022. And this is the first status conference in our office on water right application 30166 filed by El Sur Ranch for a permit to appropriate water from the Big Sur River in Monterey County. The status conference is being held in accordance with the notice of status conference dated May 23rd, 2022. This status conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and the video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site, where you will all be able to access it. The YouTube recording will also be available on the AHO YouTube webpage. If at any time during this status conference you are experiencing technical difficulties and aren't able to communicate with us, please send an email to the AHO at admin@hrgoffice@waterboards.ca.gov. There are AHO staff who are monitoring the email inbox, and they can alert me that you are having technical difficulties. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Amy Blunk, Skylar Anderson, and Kyle Woldridge. At this point, I would like to go ahead and move to appearances so we can all introduce ourselves. To do that, I will identify each of the entities that filed notices of intent to participate. And as I do, if you're representing that entity today, please go ahead and unmute your microphone and state your name. But as we proceed today, please do keep your microphone muted except when you're speaking, which helps us minimize any background noise. So I will start with the applicant, El Sur Ranch and James J. Hill III.
Good morning. This is Tom Berliner for El Sur Ranch.
Good morning, Mr. Berliner.
Good morning. This is Julianne Ainsley, who's here along with Mr. Berliner for El Sur Ranch.
Thank you. Good morning, Ms. Ainsley. California Sport Fishing Protection Alliance.
Good morning, Chris Schutz for California Sport Fishing Protection Alliance.
Good morning, Mr. Schutz. Center for Biological Diversity.
Good morning, Peter Broderick for Center for Biological Diversity.
Good morning, Mr. Broderick. Ventana Wilderness Alliance.
Good morning, Tom Hopkins for the Ventana Wilderness Alliance.
Good morning, Mr. Hopkins. Trout Unlimited.
Good morning, this is Brian Johnson for Trout Unlimited. I apologize for the lack of video. I'm out of state with my family and my internet situation isn't great.
I understand. Thank you. Thank you for joining us, Mr. Johnson. California Department of Fish and Wildlife.
Good morning, Kathleen Miller for the Department of Fish and Wildlife. I'm joined by Nancy Murray, and also with us today is Julie Vance, Regional Manager for CDFW's Region 4.
Thank you. Good morning, Ms. Miller, Ms. Murray, and Ms. Vance. California Department of Parks and Recreation.
Good morning. This is Catherine Tobias with State Parks, and also Joe Hans with State Parks.
Thank you. Good morning, Ms. Tobias and Mr. Hans. And then finally, I have, and please correct me if I mispronounce this, Kirk Gaffel. Do I have Mr. Gaffel with us today? All right, and with that, I'll look to the room. Is there anyone else who intends to participate today who has not had the opportunity to identify themselves? Please go ahead and unmute and state your name.
Good morning. This is Steve Park with the Carmel River Steelhead Association.
Thank you, Mr. Park. Good morning.
And Brian Leneve with the Carmel River Steelhead Association. Brian Leneve.
Good morning, Mr. Leneve.
Good morning.
And I think we may not have, unless I missed it, we may not have Mr. Leneve and Mr. Park received notices of intent to appear, and that's not, you're welcome to participate today. That's not a problem. I just wanted to ask you if you would please file a notice of intent to appear, because then we will have your contact information and we'll include you on our service list for any future proceedings. So there are forms available, I believe, attached to the notice of status conference, unless you've already filed one and I missed it in our filing. So please. But on that note, thank you to all of you for submitting your NOIs. What we intend to do is set up a current service list for this proceeding based on the NOIs that we've received. And we will circulate an updated service list after the status conference. I'll probably do it if there's a ruling that comes out of the status conference, then the updated service list will be attached to that ruling. The purpose of the status conference today, as I understand it, is to discuss the next steps, either to be held by the Administrative Hearings Office or the applicant necessary for the board to act on application 30166. To this end, I raised several questions in the notice of status conference for us to address. I just wanted to note that I did receive status conference statements responding to these issues from the applicant, from CDFW, and from state parks. But what I'd like to do today is go through each of the issues, and I'll note I read the status conference that those parties who submitted status conference statements. I read those. There's no need to repeat the information unless you'd like to emphasize something in particular. So with that, I think the first issue that I had raised, I'd asked the applicant whether it plans to amend application 30166, and if so, when it would submit an amended application to the division. I also asked, related to that, about the status of any environmental documentation that might be necessary to support, under CEQA, to support an amended application. And Mr. Berliner, I believe in your status conference statement, you indicated that Elsa Ranch intends to amend its application and that it could prepare an amended application to file with the State Water Board within the next 4 months. And I think if I'm doing the math correctly, that's about November 1st. And I think you also stated that you had asked the board some years ago about a firm, which consulting firm the applicant should use to prepare, I don't even know what we call this, an amendment to the EIR, an update to the EIR, because my understanding is the EIR is not certified, so I'm not sure what the term is exactly. So what I'd like to do today, I would like to set a deadline for the applicant to file an amended application. I think that's step one in all of this. We have a lot to do, but I think that's step one no matter what. So I wanted to ask you, Mr. Berliner, any input on these issues and whether you would agree that November 1st would be an appropriate deadline for me to set for the applicant to submit that amended application. So I'll look to you, Mr. Berliner.
Thank you very much. Can you hear me okay?
Yes, I can. Thank you.
Great. I think that November 1st is fine, provided that we can get some indication from the water board. And I understand that would not come from the AHO, but that we get an indication from the water board as to who they would like us to use to prepare the CEQA document and what the nature of the document will be. And we had what I guess I would call a key contact person on the water board staff who since moved on. And so we don't have a staff person that we know of to work with for these types of administrative tasks. And I could certainly send a note, let's say to Diane Riddle or somebody, and make that inquiry. But when Mr. Buckman moved on, we did not get any notification, despite some inquiry, as to who we should work with. And it's been better than 2 years. And we recognize that with COVID and all that, that everything's become difficult. But we do need to get some direction from the board as to the nature of the document they're going to expect us to prepare a draft of so that we can get that underway.
Thank you.
So, and I guess just to finish a thought, I'd be happy to report back to you that, you know, as soon as we have some information so that that could help guide whatever the timeline would be.
Right. Thank you, Mr. Berliner. I think that you went straight to my next question about the CEQA document. So I've done a little thinking about this because this is, as you know, the AHO is a relatively new office. And so we're trying to figure out how to operate efficiently and effectively, especially in these situations, you know, where the board would be the lead agency. I looked through, and I don't expect an answer today, but I just wanted to put our heads together. I looked through the CEQA guidelines, and I was looking at how we would work with a consultant and the relationship between the applicant and the AHO or another arm of the board, someone in the division. And here's the constraints that I think you're probably well aware of that we're working with. One is there are, with respect to this proceeding, the ex parte rules apply. So if you are to work with staff in the division, we would separate those functions, and that would be a separate team, as you indicated. The other piece of this is staff in the division, as you probably are well aware, is quite busy with drought work. So I'm inclined to think through a way in which we could maintain this proceeding within the AHO. So I looked to the CEQA guidelines. I was looking at 15084 subdivision D, which seems to give the lead agency a couple of options on how to structure a relationship with the applicant in preparing a CEQA document. And I wanted to point you to subdivision D3, in which the lead agency may accept a draft prepared by the applicant or a consultant retained by the applicant or any other person. And in my thinking, that may be the way to go here, where the applicant here would select a CEQA consultant and would set up that relationship. And then, you know, as needed, as input is needed, we can meet through status conferences and things like that. But that we would conduct this process, I mean, essentially it would be conducted through the applicant and the consultant of your choice. And we would work through this issue this way. But I know I'm presenting this to you for the first time here and now. So I do want to have a follow-up status conference down the road, and I think we should talk through this issue. But do you have any initial thoughts on that approach, or anything you'd like to add to the discussion on this?
Well, my initial thought, of course, is the obvious one, which I need to talk to my client about it.
Right.
But assuming that the client was amenable, and I don't have any reason to believe that the client would not be amenable, my only concern is that we work with a consultant that we're not going to get, for some reason, pushback from the board when they receive the draft. And my initial thought, because we have been working with them, is to have Provost and Pritchard do the work, because that's the engineering firm that's doing the work on the storage pond. They're also the firm that would be doing the application. So they seem to be probably in the best position to understand, you know, what the implications are of the projects that we're currently working on. But what I don't know is, I mean, I know that they do environmental work, they prepare EIRs. I don't know their availability, and I don't know if they'd be acceptable to the water board. So with those caveats, you know, the concept is fine.
Thank you. That's helpful. I think, and I understand, of course, you need to talk to your client on this. And as I said, I'm springing this on you for the first time today, and I want to have a follow-up. So let's flag this as an issue that we certainly would return to at the next status conference. And we can talk about when you've had a chance to speak with your client and possibly Provost and Pritchard. But my thinking is, and obviously they're a reputable firm, and they may have, you know, CEQA consultants may have some good information about what kind of a document you would be preparing, and that's within their expertise, and we maybe can work through that this way. I would think whatever the work product is would be some kind of administrative draft, before a draft is made public. But we certainly have opportunities to work through that. So my proposal would be to flag that and come back to it at our next status conference, if that works for you.
Yeah, that would be perfectly fine.
Great.
Your Honor, can we chime in at
Absolutely.
this point?
Absolutely, Ms. Tobias, and no need to call me. I should have said this up front. Hearing officer or Ms. Kinsey is just fine. I'm not a judge. So thank you for the respect, but please, Ms. Tobias, if you would like to jump in at this point, please do.
Obviously, I'm not with the water board and they're the lead agency, but what I would suggest actually is for their engineer to prepare their project description and then to have an independent consultant do the analysis. I'd be less than comfortable with having, their own consultant, as good as they may be, to being actually doing the SQL analysis. So I think the more usual approach would be to have, their consultant prepare the project description so that's correct and, it includes anything that they're changing. But then that really should go to an independent SQL consultant.
And by independent, you mean a consultant that would be working directly with board staff?
Correct. Thank you.
Sure thing. I gather, I don't mean to be tongue in cheek, but I gather there's no permitting by the state parks involved here. You have no interest in being the lead agency.
No.
Okay. And I should turn, I certainly want to hear, and please remind me if at any point today I seem to be moving too fast and you think I didn't give you an opportunity to chime in, stop me, and I appreciate that. I'll look to maybe Ms. Miller at CDFW. Do you have any comments on this issue? As obviously Fish and Wildlife would be a trustee agency, at least in this process, if not something more. So do you have any comments on this? And you are there, yeah.
Yeah, thank you. I would agree. We would agree with state parks on that suggested approach.
And do any of the other parties care to chime in on the CEQA issue at this time, with the caveat that we certainly will have to return to this topic? We aren't resolving anything today.
Chris Schutz with California Sport Fishing Protection Alliance. I'm not going to express opinion at this time about the who. I think it might be more appropriate to focus on the what and whether it's appropriate to try to develop a project description until we have resolved as many of the substantive issues as possible, and then at least have a number of alternatives to address on the unresolved issue. And at some point, the NGO group would like to propose a procedural approach to that when you're ready.
Absolutely. And we have a number of things to talk about today. There were many orders of, we could have done this in many orders. All the things are interrelated. So I appreciate that comment, Mr. Schutz. And I think you're absolutely right. And that's why, to some extent, I think we can only discuss these issues so far without discussing the other issues. So we'll get to that. Is there anyone else who would like to comment at this time on the CEQA process? And we can certainly return to that in the status conference if you have additional thoughts. And maybe just to follow up, Mr. Berliner, I guess, can you clarify for me more on the relationship between selecting a CEQA consultant and the preparation or the submission of a amended application? I mean, I really see the amended application as a necessity before we make much progress on this application, because we need to know what it is we're looking at. So I would still be inclined to set a deadline of November 1st, but I know you had raised some caveats, and I just wanted to come back to you and make sure I understand whether our further discussion about CEQA consultant affects this November 1st target for an amended application.
I think if we free up the timeline for when the when the CEQA document would be due from the amended application, then I don't see any problem with November 1st.
Okay. Thank you. The second issue, well, and so I should have done this in the beginning. Let me lay out the order of items that I'd like to address, just so we all know where we're going. The second issue I'd like to talk about, I had flagged in the notice of status conference, is to talk about the timing of any supplemental hearing. But what I do is I'd like to break that down and talk about a number of categories of issues that I see as maybe requiring a hearing to resolve. The first one on my list is Water Code Section 1004. I also have the question of interim flow conditions while the application is pending. Third on my list are the two remaining matters in dispute that are identified in the settlement agreement, or the proposed settlement agreement with CDFW. I think we should talk about that. And then finally, last on my list, there is the issue of the amended application and CDFW's proposed streamflow requirements. And I think all four of those are potential issues for a hearing process. And I'd like to talk about each one in turn. And then once we get through those, I want to talk about next steps and when we might meet again and where we are. So I apologize for not putting that agenda out up front, but that's where I'm planning to go. So second, I had asked about the timing of any supplemental hearing. And I think related to that will be the scope of any supplemental hearing. As I mentioned, the first issue that I see as potentially requiring resolution through a supplemental hearing is this question of the application of Water Code Section 1004. The issue, I believe, was initially raised by CDFW in its protest once upon a time to the application. But I understand it was not addressed in the proposed settlement agreement between the applicant and CDFW. It's also not clear to me at this point, and I will look to the other parties, but it's not clear to me whether any of the other parties would plan to raise this as an issue in any supplemental hearing or closing briefs or other arguments about the potential approval of the application. It does occur to me that this is possibly a preliminary issue that we may want to address before the applicant spends a lot of, and all of us participating, spends a lot of time and money on a CEQA consultant and working through the application process and preparing for a hearing on remaining issues. Based on the status conference statements, my understanding, Mr. Berliner, is that the applicant believes that the issue can be resolved by completing the settlement agreement with Fish and Wildlife, as I understand it, resolving those two remaining issues identified in the settlement agreement. I'm a little unsure about this because the settlement agreement would, of course, bind CDFW, but not the other parties. So I'm not sure how that would resolve the 1004 issue if any of the other parties are planning to raise it. So I'm going to look to each of you on this, but I wanted to turn to you first, Mr. Berliner. If you have any thoughts or care to address how you think the AHO should address, in terms of process, should address the Water Code Section 1004 issue.
A couple of thoughts. So far, all of the parties have agreed to the settlement agreement in its current status. We have the two open issues. The 1004 issue is subsumed under the settlement. In other words, the limitations of 1004 are not the boundaries of the settlement. So the amount of water that is applied under the settlement exceeds the amount of water that would be applied under 1004. So while it's not explicit in the settlement, it's not implicit. And the 1004 issue was discussed during the water board hearing and not resolved because there was never any order from that water board hearing. So the only thing that came out was a hearing officer's opinion on that. And I'm sure you've had a chance to read that, as have the others. And that was a pretty heavily caveated opinion, and made very clear that it was the sole opinion of the hearing officer who's no longer with the board. So if the settlement becomes the basis for the order moving forward, then the 1004 issue is really resolved. So if we don't have a settlement as to all points, we still have the open issues in the settlement, but my sense is if the settlement is acceptable to the water board, then the 1004 issue just goes away, it takes care of itself. So I understand the question you're asking me. I certainly do not disagree that it's a preliminary question and should be resolved before the others. However, the structure of the settlement does take care of that issue. And if the board ultimately accepts the settlement as resolution, even if we end up having to have part of the settlement resolved by the board, then the issue is taken care of. I think the only problem would be, which I'm not really foreseeing at this time and don't have any reason to, would be if the settlement would fall through. But based on our experience with the board over a pretty long period of time now on this case, it seems that the parameters of the settlement are quite acceptable to the board. And again, obviously, we don't have a ruling from the board itself, but all discussions so far, including the hearing that we had, there did not seem to be any resistance to the basic parameters that we already do have resolved. And we really just have these two outstanding issues as far as the settlement agreement itself is concerned to take care of.
Thank you, Mr. Berliner. I think I believe I understand, which is your position here, which it sounds like if the two outstanding settlement issues are able to be resolved, that may be the appropriate area of focus, because if those can be resolved, then potentially this 1004 issue is no longer an issue. So, I mean, it's a little bit of a chicken and the egg, but I think I understand that what you're communicating to me about.
Yeah, I think that summary is right. If we get through the others, this issue goes away. If we don't get through the others, but the board resolves them, the issue goes away.
Yes, understood. And we'll turn back to those two issues and a process options for working through those in a moment. I will turn to you, Ms. Murray. I see your Zoom hand is raised. So if you would like to comment, please go ahead at this time.
Thank you, Ms. Kinsey. So the CDFW does believe that the Water Code 1004 is still a live issue. You mentioned supplemental hearing. We believe there's been testimony and closing briefs submitted on this issue, so I don't believe we would need a supplemental hearing regarding that issue. We are still very unresolved on any draft settlement that hasn't been fully implemented, so would not want to rely on a partial draft settlement for a resolution of 1004. So bottom line, 1004 is still a live issue, does not need supplemental hearing.
And maybe, thank you for that. Maybe if a follow-up question, I'm trying to figure out how to phrase this, but maybe it's a characterization of what the settlement agreement is. My understanding was that the settlement agreement is CDFW has agreed to the terms and conditions with the exception of the two unresolved issues. Is it, maybe you can clarify for me, is it your understanding that the settlement agreement is at this time binding on CDFW, or with the exception of the two issues that are flagged in the agreement and unresolved, or is the settlement agreement still in a suspended state until some final resolution of those two issues?
I believe the draft unsigned settlement agreement that is partial, that only addresses some small subset of issues, is not binding on CDFW or any other party.
Right.
And I'll chime in here to add, Ms. Kinsey, really the settlement agreement, all of those terms really need to act in concert with each other. So it's hard to agree permanently to certain conditions without the full package.
Thank you, Ms. Miller. I think I understand, but my understanding is if there was resolution of the two outstanding issues and a package was the full agreement is executed, at least in concept, the concept of applying more than 2.5 acre feet per acre to the property is acceptable to CDFW, potentially if there's a full settlement agreement that is executed.
We don't know what a full settlement would look like at this time.
Okay. I'll look to the other parties, but first I'll look back to you, Mr. Berliner. Do you have any? Do you have anything you would like to comment on about the characterization of the settlement agreement?
Candidly, the position that I'm hearing this morning from the department is different than my understanding. So I think there may be a need for us to have some further discussion with the department, because it was my understanding that with resolution of the two open issues and obviously preparation of a proper settlement agreement, that we have resolved the issues that have been the basis for the discussion between the applicant and CDFW. And all of the other parties have participated to some extent in these discussions, either where I've been on conversations with them, where all the parties have been on conversations, but there's been a considerable amount of conversations that have gone on over the last few years about how to resolve this.
Thank you, Mr. Berliner. I will look to the room. Maybe I'll turn to you first, Ms. Tobias, as the other state agency here. Do you have any comments about either the status of the settlement agreement or Water Code Section 1004? Is there anything you would like me to consider on those issues or your participation in the settlement agreement?
No, not at this time.
Okay.
Thank you.
Anyone else? Mr. Schutz, I see you going off mute. Please go ahead.
Yeah. As Mr. Berliner stated, there has been considerable discussions in the last several years regarding potential settlement. It's been my view that the parties generally feel that until there's a complete settlement, none of the terms of the settlement as such are binding. Our recommendation for resolving this issue would be to give the parties a certain amount of time. We'd recommend 3 months to either resolve the outstanding issues or decide what they could stipulate to as resolved and bring that back to you in some kind of joint conference statements, joint status conference statement, in order to resolve these issues, because if indeed not all of the outstanding, the big outstanding issues are resolved, then there needs to be a secondary discussion about, well, what about those that we've tentatively resolved, thinking we were going to resolve all issues? How do we all see that? And in that instance, I think it would be useful to the degree possible for all parties to commit that to paper. So that's what I'll say right now.
Thank you, Mr. Schutz. Ms. Miller, I see your hand is raised. Please go ahead.
Thank you, Ms. Kinsey. I just wanted to clarify for the hearing officer how CDFW would characterize the outstanding issues for the settlement agreement is that we don't believe at this time they're likely to be resolved without board intervention. The parties have put in 11 years of discussion. There has been movement, but I don't believe at this time resolution is going to be possible without board participation and intervention.
Thank you, Ms. Miller. I think since we're going in this direction, I'd like to skip to what I have as number 3 on my list, but let's talk about the two outstanding matters in dispute identified in the settlement agreement. I know, Mr. Berliner, you had in your status conference statement, I believe, indicated an interest in mediation, and you can correct me if I'm wrong. And I do think if that's the interest and the other parties are interested, I think the board could provide a venue for that through the AHO. It's something I would like to explore further. It's something our office can offer. I think it would involve a separation. One of our other hearing officers might be able to serve in a mediator capacity. And I think also it might be efficient with our time. This is something that could be done while, or at least begun while working on that amendment to the application and then working on the CEQA document process. What I was thinking on this, again, we're talking about this here for the first time. I think all of us would need to go back. I need to work with board staff and find out what, in more certain terms, what we could offer. And when we meet again, we can talk about it further, but maybe I'll turn to you first, Mr. Berliner, if there's anything you want to add or clarify for me about the request from the applicant for board intervention on these two issues.
I don't think I have anything to clarify. I think you understand the issue. I was thinking that it would be through AHO, and we certainly could litigate these issues. The one on the question of how much time is necessary to process permits, I don't really think is sort of a litigable issue, if you will. I think it's a decision that needs to be made, and it would be a very unusual one to have a hearing on. But there are different viewpoints, and I think a mediation environment might be appropriate to discuss it. In other words, I accept that it's a live issue and one that does need to be resolved. It's just, to me, the sense is that a better way to resolve it is administratively rather than through some sort of judicial type proceeding, because I don't really know how you litigate that kind of a question. The other one is more of a kind of a fact-based issue, and there is information in the record on that. But I do think that mediation would help, and that was why I made the suggestion, because we have tried among ourselves to resolve it, and at least at the moment don't appear to be able to. And I would think that having somebody come in who's got experience in the area, and I don't mean it necessarily has to be an engineer. I think a water law attorney could be just as as helpful. To resolve it might be useful, and the AHO may be the place to do that.
Thank you. I'll turn back, either Ms. Miller or Ms. Murray. Do you have any comments on that? Do you think mediation might be fruitful here through the board, or do you think we, cut through the process, go straight to a more adversarial hearing process? Do you have any comments on the process here?
Yes, thank you. We're not opposed to mediation as long as it's done in parallel with the amendment process and there's no delay. So I think we would ask that you set a hard date for those, a hard deadline for both the submittal of the amended application and the close of any mediation. And then we can set a further pre-hearing conference statement to talk about what are the live issues that are going to hearing. I think ultimately we want to see this issue resolved. It's been pending for the board between 28 to 30 years. And so we would ask for a hard deadline on that.
And that makes sense to me. I mean, where I'm coming from, I think our role at the AHO when we receive these assignments is to move these matters forward. That's very much our role. We can do it through setting essentially time schedule orders to move this forward. And I would like to see us working in parallel. A lot of time has passed, and I think at this point we need to press forward. But I'm happy to hear that mediation is something that you would be willing to participate in and might be a useful process here. So I will also look to the other parties. Does anyone else want to comment on the two outstanding issues in the settlement agreement, a possible mediation process?
Thank you. I'll speak up briefly. Just procedurally, we're in harmony with Mr. Schutz, and I think Ms. Miller, I think it makes sense for the parties to return to some sort of pre-hearing conference with hopefully a joint statement of the issues that remain to be heard. And potentially at that time, we could reach agreement on some ancillary issues if that's possible, and kind of peel those off. But I will reiterate that we don't have a final signed settlement agreement at this point, and we don't object to mediation in parallel.
Thank you, Mr. Broderick. This suggests to me that, well, let me pause here. Does anyone else care to chime in at this point before I start talking? I think what it suggests to me is, in addition to setting that I'm creating a kind of a checklist of what is going to come out of this status conference, I'm going to be setting a deadline for the amended application. I also think it sounds like we will be setting a follow-up status conference, and we'll talk about dates for that. But right now I'm tentatively thinking early September. And it sounds to me like one of the work items in preparation for that status conference would be an identification in status conference statements, and ideally maybe a joint status conference statement of the outstanding issues that might be referred for mediation, so that we can be clear about what it is that it remains outstanding and what would maybe go through mediation. Would anyone else like to comment at this time about those action items? Maybe I'll ask this just to be clear, Mr. Berliner, if we moved away from the 1004 issue, we started talking about these other issues, but I just wanted to understand, and this question is geared towards understanding whether Water Code Section 1004 is potentially a dispositive issue. Would it be if the board were to find that 1004 applied to Elser Ranch's amended application, would that would Elser Ranch continue to pursue its application, or would that be a potentially dispositive determination that would essentially cause the ranch to withdraw its application? Do you have any? Are you able to make a statement on that at this time?
No, I'm not able to make a statement on that at this time.
I mean, you can understand
I would
why
need to discuss that with the client.
Okay.
It is I suspect it could have the effect of putting the ranch out of business. And that raises all kinds of issues about the disposition of property and what the ranch would want to do. And obviously it's an existential question for them.
Right.
So there's probably not going to be an easy answer to that. I'll have to have a discussion with the ranch about that.
Thank you.
I prefer not to have that discussion, frankly. But if that's an issue that's going to have to be resolved before we get going, then I will have to have that discussion with them.
Thank you, Mr. Berliner. I mean, I agree with you. It may not be necessary, although you can understand where I'm coming from, and just I'm thinking about it purely in procedure of structuring this hearing efficiently. If that's not truly a preliminary issue that would be dispositive of the application in advance, it may make sense if we do end up having a supplemental hearing, if there is not a settlement agreement, then we just roll that all into one, which is the reason for the question. But I think we have some more work to do before we get to that decision, if we get to that decision. I did want to turn to, well, I'm going to reserve the issue of the interim flow conditions to the end. I also wanted to understand within the scope of any supplemental hearing or settlement agreements, there's the matter of the evidentiary record that's been developed in this proceeding to date. Obviously, the amended application, it hasn't been filed, so it's not part of the record. Once it's filed, then those amendments to the application would, of course, be, I think the parties would have a right to present evidence about the amendments to the application if there's no settlement agreement. The other matter here is CDFW's proposed stream flow requirements. Those are not part of the evidentiary record at this time because they post-date the hearing in this matter. So there does need to be a mechanism to bring those into the record because Water Code section 1257.5 requires the board to consider those in acting on an application. And I think that's in some ways, regardless of the settlement agreement, those would have to come in, whether they need to be, whether the parties can agree to bring those into the record. We maybe can do that without having any kind of, Zoom, I think would be a Zoom hearing, but any kind of Zoom hearing, we would just do it on the papers. And then there's the matter of whatever CEQA document comes up that would need to be considered by the board and in some way. And if there was opposition to that CEQA document, we would have to have potentially a hearing process for that. I know Fish and Wildlife, from reading your status conference statement, you suggested that you didn't think any supplemental hearing was necessary. And I just wanted to clarify my understanding of that. My understanding from that statement is that you wouldn't be seeking to present any evidence about amendments to the application or in support of your stream flow requirements. Is that, but maybe I'm misunderstanding. So I will turn to you, either Ms. Miller or Ms. Murray. Will you please clarify what you meant by you don't think a supplemental hearing is necessary here?
Yeah, I think maybe our understanding has shifted since we filed this. But originally our understanding was that we would ask for the board to make a decision on the original application, but it sounds like the project is intending to amend. So I think that does change the necessity for a potential supplemental hearing. And thank you for the clarification about the stream flow recommendation. We were unclear if that was part of the record or not.
Thank you. So my understanding, to follow up on that, would be obviously dependent to a large extent on any settlement agreement, that CDFW may seek to present evidence on an amended application, the proposed stream flow requirements, a CEQA document.
Yes. Yeah.
I will get back to Mr. Berliner. If you have comments, I'll get back to you, but maybe I'll look to the room. Does anyone else want to comment on the issues that might be addressed in a supplemental hearing. I understand this is contingent in large part on whether there's a settlement agreement in place, but any other comments? I see Mr. Schutz, you're off mute. Do you have a comment?
I do. I'm thinking about the sequencing of these different things, and that's going to be important. I think mediation and some effort to stipulate to agreed to conditions would be a appropriate first step. I think it would be necessary to define outstanding issues, both for briefing and for hearing, if any. My recommendation would be that any hearing that went forward would be limited to, at most, to issues that could not have been raised in the past, such as the report of the department on in-stream flow or the amended application. It's not entirely clear to me whether it's even necessary to present evidence in a hearing process on the report itself. I think that's something the parties ought to discuss either in mediation or otherwise. The question is not so much that there's a report or what it says, but sort of what it means and how it applies to this case, which is kind of a separate issue from the technical merits of the report. But in the event that you do decide to have a further hearing, I would not want to retread the ground that was addressed in the previous hearing. I think that briefing would be adequate to and appropriate to address the issues that were previously raised.
Thank you, Mr. Schutz. That's helpful. And just to indicate my position, I really don't have an interest in redoing the entire hearing. There's an extensive evidentiary record, extensive time and resources was put into establishing that record, and it's thorough. But as you point out, there are certain items, and that's what I intended to flag here. There are certain matters that just were not part of that record and part of that hearing because they couldn't be because of the timing. So before I turn back to Mr. Berliner, does anyone else want to comment at this time? Mr. Berliner, would you like to comment at this time on anything we've discussed so far?
Thank you very much. I do agree that we certainly don't want to redo the hearing. The two open points, if we're not going to resolve them otherwise, I agree, need to be part of the hearing. To the extent that the hearing officer's opinion on the application of 1004 has come up or would be an issue to be considered, we want the opportunity to respond to that, which I believe is our right, and to present contrary evidence that we think is applicable to the analysis that was applied by the hearing officer. With respect to the IFIM study that was done, I think I agree with the way that it was characterized by Mr. Schutz, which is we've had an opportunity to review the study. Yes, there are some points of critique to the study, but I think the bigger issue is what's its relevance to this application and whether it would change anything, given that an IFIM study typically is applicable on a stream that has regulation. This is an unregulated stream, and the flows are what the flows are. And the impacts of the pumping is what the impacts of the pumping is, all of which we already know, and which is really not changed by that study. So I think if I've understood how Mr. Schutz articulated it, we would have the same position.
Thank you, Mr. Berliner. I believe the last item on my list that I wanted to at least give an opportunity to hear comments on is the issue of any interim flow conditions while we work through this process. My understanding, Mr. Berliner, is that the applicant is voluntarily complying with the interim flow conditions described in the draft or proposed settlement agreement. And I wanted to hear from all of you about whether there are any concerns about continuing the approach with essentially voluntary compliance by the applicant, and whether there are any comments on that. I will turn to CDFW first. Ms. Miller or Ms. Murray, do you want to comment on interim flows and how we handle that while this matter is pending?
I think I would like some clarification from the ranch about what they mean by interim flows. My understanding is there's a paragraph in the draft settlement agreement speaking to 10 CFS at the bypass flow. But I don't believe we've been able to verify whether those flows are occurring and
So,
the adequacy. Yeah.
Thank you, Ms. Miller. You're right. To be fair, let me turn to Mr. Berliner first. Maybe you just summarize for me what the current status is about the ranch's operations with respect to flows in the Big Sur River. And I believe the characterization that I believe it's in your status conference statement, correct me if I'm wrong, that the applicant is voluntarily complying with interim flows described in the draft settlement agreement.
That is correct. The ranch is operating according to those flows and is ceasing operations on the long weekends as specified. So, and that's been ongoing for a substantial period of time now. And the applicant has already started implementing the non-flow measures of the settlement that were called for. And that has been going on now for probably at least 4 years.
And maybe briefly, Mr. Berliner, can you describe to me the non-flow measures that you're referring to?
Yes. Yes, I should clarify that because typically I'm not referring to in-river non-flow measures. I'm referring to a series of best management practices that were agreed to between the applicant and CDFW as part of the overall settlement. And a lot of it has to do with land management type activities. The settlement is a single settlement concept, but there are kind of two parts to it. One is the flow part, the other is the non-flow part. And there were a number of measures that were specified, quite a few that were specified and agreed to between the ranch and the department. And it's that list that I'm referring to that's been partially and will continue to be integrated into the ranch's operations. And several of them are just long-term management type activities that have been integrated in. So they'll just be ongoing as opposed to one-time activities.
Thank you. I appreciate that. I will turn back to you, Ms. Miller, in a moment, but I see Ms. Tobias has raised her hand, so maybe I will turn to you first. Would you like to comment?
Thank you. I just wondered if that is still flood irrigation being used for what they are doing in the interim.
I can, sure, let's ask that. Mr. Berliner, can you respond to that?
Yes, it is flood irrigation. That has proven over time to be the viable option for irrigating the ranch during the course of discussions and during the hearings. There was some question about, well, what other methods could work, and I could go into it now, but I could also just say, look, we've looked at the others there because of the location on the coast. There's lots of problems with other traditional types of irrigation, and they just don't work because of conditions along the coast.
Thank you. I appreciate that, Mr. Berliner. Ms. Tobias, did you have follow-up on that with that clarification?
I'll have to go back to the record and review that. I'm not really aware of other property owners still using this kind of irrigation. Although I understand that the ranch feels that this is traditional, I'm not sure it's really a viable way to use water at this point, but I'll go back to the record and check that. Thank you.
Yeah,
Thank you.
And I would be, to the extent it's useful, I'd be happy to have a discussion with Ms. Tobias or have the ranch meet with park folks to discuss it.
Okay.
Amenable to whatever the park would like to do on that.
Thank you.
Thank you. I appreciate that. Ms. Murray, I see your virtual hand, please.
Just briefly, so the 10 CFS that Ms. Miller mentioned in one paragraph where we felt like we're getting an application, amended application submitted quite soon for the reservoir, didn't happen. And as 10 CFS is quite a bit lower than anything in the record. So we agreed to a very low amount based on the idea that it would an amended application would be forthcoming some years ago. So we do have concerns about this very low amount continuing more. And so that goes back to deadlines and maybe a time schedule order and some consequence of a higher amount if those deadlines are not met.
Thank you, Ms. Murray. Maybe if this is a fair characterization, and please caveat this is if this is not quite right. Your CDFW is willing to live with the continuing generally described 10 CFS minimum flow or bypass flow or minimum flow. I'm not sure it's a bypass, but not as long as we are making a diligent process in this proceeding, but not to go on for additional years. Is that generally accurate?
Right, it is inadequate. 10 CFS is inadequate. And while the ranch says they're voluntarily implementing this 10 CFS, they could also voluntarily report that because we are not aware that they are actually doing that. And we have some suspicions that there's been times when they're not. So we would like to know and have them report.
And by report, can you clarify for me what you mean by report? What would that involve?
Report to the water board, like as if there was a license issued. I understand it's an application, so maybe they're not required to report what their diversions are and what their bypass is at their diversion point. Most licenses, if you have a bypass, require you to measure not only what you're pumping, but what you're bypassing.
Maybe I'll turn to you, Mr. Berliner, to clarify for me. I don't recall from the record. Is there a measurement? Is there a way to measure the compliance with the voluntary bypass flows?
There's a gauge on the river, and so we have been using the gauge flows for all purposes here, both for the interim and the long-term actions related to river flow. So we would continue to do that, and we could report I'm not sure the context in which we would report to the water board. We could report to CDFW or to the parties in the proceeding to confirm that we're abiding by those conditions.
Thank you, Mr. Berliner. That's what I was thinking. I mean, this is occurring to me at this time, so we're all thinking this through, but what occurred to me is that we could set up a schedule of regular reporting updates in a way that I want to discuss the burden on the applicant, but if this is measured, that we would have regular updates and that would be filed through this hearing process, and then we would have it in the record and it would be available to all the parties here. So that is something I would like to flag that as something we should discuss further, and I think may be appropriate to set up while we're proceeding forward, so that there is some record of what the flows are, what diversions are, and compliance with these voluntary measures. I think what I'll do is I'll add it to the list of things we should discuss at our next status conference. I think I'll ask for a proposal for a compliance and reporting plan. I don't care to do anything extensive, but it sounds to me like something fairly straightforward could be arranged so that we have some kind of regular reporting on this. And I would look to input, of course, from CDFW and state parks and all the other participants about what might be appropriate here, as well as, of course, from the applicant. Ms. Murray, do you want to chime in on this?
Yeah, I do think that it shouldn't be an undue burden, because once they get a license, they're going to have to do something very similar, if not more. So this is a good step in the right direction to get more assurance of their compliance with a very compromised bypass that we agreed to some years ago.
Thank you. And thank you to all of you for your input on this. Is there anyone else who would like to chime in on the interim flow or interim bypass measures issue, with the caveat that we will return to this? So Mr. Schutz.
I think it would be helpful. I don't know that we need to do that now, but my understanding is that the gauge that's being used as the basis of the interim flow is also the gauge that the ranch has proposed as the basis for the proposed long-term flow. And that is something like 7 or 8 miles upstream of the point of diversion. If I'm mistaken in that, I'd be glad to be corrected. But I think that's an important point of understanding that everyone should have, so that it's not a surprise when we all come back to a reconvening of a status conference.
Thank you for that clarification, Mr. Schutz. And that's why I started asking the questions. The gauge is not always exactly where you would necessarily want it to be, but just by especially on in a coastal stream like this. So I think what I will do in asking for a proposed compliance plan, Mr. Berliner, and I imagine you would, that a description of where compliance would be measured, where the gauge is. Maps are always wonderful, and then we can all have a common understanding of what is being reported and where the data is coming from and that kind of thing. But I think you are quite capable of working through that. So would you like to comment, Mr. Berliner?
Yeah, no, we can do that. I mean, the gauge it's the same gauge that's been referred to all along in this proceeding, and there's a specific gauge number that can be called up quite easily. If anybody wants to look at it, you can actually just Google the Big Sur River and flow gauge, and it'll pop up. So it's quite easy to access.
Thank you. Ms. Murray, is that, would you like to chime in again?
Yes, just if the gauge is 7 or 8 miles upstream, and the ranch would also need to report their daily pumping, because they have pumps, they have gauges on the pumps. Again, something they're going to have to do when they eventually get a license, and that would help inform the whole calculation.
Thank you, Ms. Murray. And Mr. Berliner, I'm not asking for a commitment. I know you need to go back and talk to your client, but do you think daily pumping, not that you would report it daily, that's not what I mean, but records of daily pumping amounts would be something that is the applicant is capable of doing, or are you able to comment at this time?
I could be wrong on this, but I do not believe that the way that the pumps meter the water is capable of a daily read. It is certainly capable of a monthly read, but I would have to check about whether it is in fact capable of a daily. It requires I don't want to get too far ahead of myself on this, but my understanding is that the gauges cannot be read remotely. They need to be read by a person that goes to the gauge.
Yes.
That is a common event at the ranch, that somebody does go to those pumps to operate the system. And it may be a question of personnel to be able to actually do that. The ranch, because of its location, operates on a very thin staff, and the staff doesn't go every day down to that part of the area because they have responsibilities elsewhere. But there are only 2 or 3 people that are there, and so it's a very lean operation. But I'm going to have to ask for some detail on it as to how often it could be done without totally disrupting their labor situation, which is, like everybody seems to have labor problems, but given their location, it's hard to get workers down to that part of the Big Sur area. So, but I'll get back to you on it, on what a meter read schedule would be. And I understand there's some that are required by law, so those have to be abided by anyway.
Thank you. I appreciate that. And there may be, I think we should think too about whether there are certain periods of time that may be more critical than others, so we can structure this efficiently. Ms. Murray, I will turn back to you, please.
Just briefly to note, this is the 21st century, and the department has been working in a very remote location with SCE. They were like, no, we have people, they go up and do it manually. They have switched a solar panel. We're getting hourly, daily reads. It's much more efficient and something that the water board should be willing to order anyway. So this would be a potential issue for us to discuss in further briefing, further mediation, further order, because in order to know what they're doing, they need to be able to not just set a pump and leave for a month, but actually monitor what's happening in the river and what they are pumping and reporting.
Thank you, Ms. Murray. And I realize too, there are somewhat 2 elements to this. There's the interim, there's the very short-term plan of operation. There's the potentially longer-term plan of operation while we move through this process, if it takes, more than a few months, which it probably will. CEQA does take some time. And then there is, of course, the long-term, if a permit is issued, how compliance would be measured there. So I realize we're dealing on this in multiple fronts, but I thank all of you for bringing this up early. It's important, and I think it'll be a good topic for us to revisit. Is there anything else that we should talk about? Any other procedural items before I turn to what I think I see as the next steps in this process? One of which is to come to some mutual understanding of a date for a follow-up status conference. Is there anything else we should talk about? So I think in terms of next steps, as I mentioned, I'm going to plan to issue a procedural ruling out of this status conference that'll will set a deadline for the applicant to submit an amended application. And then we'll also we'll schedule a follow-up status conference. I'd like to do it in early September. So we have a placeholder to check in unless any of you have a different suggestion. So if we can, maybe at this time, I'll open our calendars and take a look. I'm going to flip to September. Maybe I'll just turn first. If we look to the week of after the 5th, I believe the 5th is Labor Day, but the 6th through the 9th, do any of you have conflicts that week in setting a follow-up status conference, or do any of you have suggestions that we should either meet sooner than that for any reason? So we're looking at September 6th through 9th. And you're going to let me know if there's any obvious conflicts that you would not be able to participate during any of those days.
This is Tom Berliner.
Please.
I have a conflict on September 9th.
Good. We will not do the 9th. Anyone
Okay,
else?
Thank you very much.
Of course. Mr. Sheets.
I think in order to evaluate whether that sort of timeline is appropriate, I would appreciate it if you could sort of reprise the issues that we're hoping to address, including whether it is your hope that the AHO will have some news about a potential mediation at that time, or alternatively, whether perhaps later in the month or the beginning of October might be appropriate if, in the absence of mediation, we were going to try to hash out among the different parties the areas of agreement or non-agreement that we feel need to be addressed. Thank you.
That's a good question, Mr. Schutz. Let me try to answer as best I can, and then please follow up if I'm not clear. My understanding of this next check-in, first of all, I want it as a placeholder so that we keep things moving forward. My understanding is that I would come into the status conference, ideally, after describing to you in advance of the status conference in writing what the board can offer in terms of mediation and what that might look like for our discussion. I also would put in writing any additional thoughts or intentions I may have about how we might structure the proceedings so that we could respond to that proposal at the status conference. I do not anticipate the status conference would, at that point, get into setting any kind of firm hearing schedule. If it looks like we need to proceed to a hearing and that's the next step, I think that would be the topic of discussion at the status conference. Do we need a hearing? And then we would have some follow-up status conference to work out the specific details. So I think because there's so many moving parts that we've identified, my intention is to move at this kind of iteratively, and we can meet as needed. Some of these status conferences can be very brief. We don't always need to do an hour and a half necessarily, but I think it's a good way to just keep this moving forward, which is why I'd like to schedule it early. But my intent would be to bring to you, all of the parties, more information about what the board can offer in terms of mediation, and then also in my plans in how I see this proceeding forward. We would have a chance to meet, and then coming out of that status conference, we would have a better understanding as to what the next steps are and whether we need to set, I imagine we would set additional deadlines, but what those would be for. Does that help, Mr. Schutz?
It does, thank you. That said, I think I'd recommend that it not be the day after Labor Day, and otherwise I have no conflict.
That's probably fair. Okay, thank you. So with that, I'm going to look at September 8th. I propose the morning at 9 a.m. once again. That seems to work well. But are there any conflicts with September 8th starting at 9 a.m.? I would set a deadline for status conference statements on any issues that I may raise for some. I would probably set it for the Friday. Well, let's see. I don't want to jam anyone on Labor Day weekend. I think I would set the deadline for status conference statements for Tuesday, the 6th. You, of course, can get them in early. If they're, well, they probably won't be. I will ask for status conference statements on issues that I'll identify in the notice of status conference, or responding to the proposal for mediation and that type of thing. But if you're not able, if there isn't, just tell me what the status is. I mean, if I realize we're on a short schedule, I just want to keep this moving forward. If you need more time to negotiate that type of thing, well, tell me that in the status conference statement. That's fine. Ms. Miller, I see your hand. Please go ahead.
Yeah, thank you, Ms. Kinsey. I'm just wondering, in the interest of time and moving things along, and I realize the AHO has a certain calendar. Is it possible to hold an earlier pre-hearing conference statement just on the issue of what the water board can offer in terms of mediation? I think the parties would like to not further delay that process.
And when would you, and what would you propose?
Sometime in early August, so like a month sooner than what we're talking about now. But I realize you have constraints, and it might take some time.
I think based on the AHO's calendar, I understand. Here's what I can commit to. What I will commit to is sending to you, to the parties, a description of what the AHO thinks it can offer in terms of mediation and what that might look like. And then all the parties will have a chance to and maybe you can confer with each other. That might be ideal. And you can begin those discussions. And I can get that to you in early August. And then when we meet about a month later, perhaps those discussions will have made some progress. So I will put the proposal out there for mediation and what that might consist of. And then I probably would ask the parties to meet and confer about whether that might be an acceptable process. Would that be an appropriate compromise given everyone's schedules? Does that make sense? Does that help move this forward?
I think getting the information sooner would be very helpful.
I think that we've exhausted the items on my list, so I'll turn to the room. Are there any other comments, issues, matters we should talk about today, matters you'd like to raise? I know there are so many moving parts here. We don't have a firm, clear outline of how we're going forward, but I think we have some clear next steps. And as we move through this at each point, I think we'll get additional clarity as the most efficient way to address all these issues. I do want to say that I really appreciate all of your cooperation and constructive approach to all of these issues as we try to work through them in a way that makes sense. Anything else before we adjourn for the day?
I have a question.
Please, Mr. Berliner.
Yeah, the question I have is what you see the role of the non-parties to the proceeding being. There were a number of entities or parties that, or people, I should say, that filed notices of intent that are not parties to the proceeding.
And that would be, I haven't gone back to look. Do you know who on the top? Do you have someone in mind?
Well, for instance, Parks is not a party. There are various individuals that are not parties. There may be some entities that filed that are not parties. There is a party list that includes CDF, the applicant, of course, CDFW, CalSPA, Let's see. CBE is a party. The Brian Leneve's group is a party. So there are a small group of folks that participated in the hearing and that are parties to the case. And then there's the rest of the people, various people made policy statements or, but there were many people that made policy statements. So that's my question.
Yes, this may be a partial answer, and thank you for clarifying. I wasn't quite sure. My understanding is most of the people appearing on this call, with the possible exception of State Parks, were parties to the proceeding, and those who have filed NOIs to participate in this proceeding, for the most part, were parties. In terms of the policy statements and those who have not chosen to file an NOI for this status conference and have not chosen to continue to be notified with respect to updates in this proceeding, it appears to me that these entities have chosen to no longer participate in the proceeding. So I don't have a firm, it's a good question. I'm not sure I have a firm answer today, but from my point of view and based on the status conference notice, entities were required to file an NOI to continue to participate in this proceeding, to be on the service list for this proceeding, and those are the entities that I would consider to be the active participants. Now, I think State Parks, that's another question, but State Parks is, in my opinion, this is not a ruling at this point, but is an important element to this conversation, and I would encourage you to work with State Parks on any agreement. Does that address some of your concerns?
I think my concern is we have no objection to working with State Parks on any issues they may have. We've been good neighbors and cooperate with the park all the time. But in terms of any litigation going forward, that's what I really want to understand, where the roles would be of the entities that were not party to the proceedings in front of the water board.
I understand. Yes.
And I'm not referring to policy statements. I mean, actually presenting evidence and litigating the case.
Right.
I'd be happy to address that.
Sure, please. Respond.
Not at the moment, but with something written. We participated, I think, all the way along. We filed an NOI in this proceeding. We have some serious concerns about the impact of use this water and the commitment of water to flood irrigation on our lagoon, which is basically losing water. So, which has rare and endangered species in it. So, if you'd like something in writing about, why we're a party, I'd be happy to submit that.
Thank you, Ms. Tobias. I think what I will do is let me take a look at what I think an appropriate approach would be, and I will provide both State Parks and the applicant and any other party an opportunity to respond on this issue. But let me take a chance and I will address it. I'll look at it and I will address it either in the ruling that comes, not ruling on the matter, but just asking for additional information. Either in the ruling that comes out of the status conference or in the status conference notice that comes next. So we will plan to work through this issue so that everyone has a clear understanding of who is a party to the proceeding and what their respective rights are to participate in the proceeding. So thank you for raising that, Mr. Berliner, and thank you, Ms. Tobias, for offering to provide additional information.
Thank you.
Briefly on that, Ms. Kinsey, I'd like clarification if I could from Mr. Berliner. My understanding is that there's going to be at some point an amended application and a hearing on that amended application. And I'm wondering, Mr. Berliner, if it's your position that that hearing on that amended application is limited to parties that have already participated as parties in litigation. Is that the position you're taking right now?
That's a good question. I don't have a position on that at this point.
And I think, Mr. Broderick, from my point of view, that's exactly the question we're considering here. And
Very
it's one that I think the part of my role will be to participate in that decision. And I don't think there's a clear answer. I mean, this process where we have a 10-year-old more 10-plus-year-old hearing, and then we are reinitiating that hearing to some extent as the matter has been assigned to the HO. This is not something we've done before, so we'll have to work through those together. But I certainly will give everyone the opportunity to make arguments or present information on this issue.
Very good. Thank you.
Thank you.
Just a point. I think, Mr. Broderick, you're already a party to the proceeding.
That's right.
And thank you, Mr. Berliner. It points out part of this, because we haven't issued a hearing notice here. Normally the process for the AHO and the hearing notice is to identify who we believe the parties are. And because we don't have a hearing notice here yet, I haven't done that. So that may be a useful exercise for me to at least identify who it's our understanding are parties to this proceeding at this point, and then identify whether we would, well, I would invite others to ask to become parties, and then we can work through how that process might work.
Thank you.
Thank you. Anything else, please, before we adjourn for the day? These are all quite helpful, good issues.
Yes. Hello, I'm sorry. Steve Park with the Carmel River Steelhead Association. Both Mr. Leneve and myself did file NOIs. I saw a lot of traffic on my emails after those NOIs were filed that showed a lot of the participants that were on the list of those who needed to file NOIs did not respond to the emails and were not on board. I guess the comment I would make then is that since we did, Carmel River Steelhead Association did file NOIs and did see a lot of people who were supposed to be NOIs and weren't. They just either have moved on to other positions or whatever. So I just want to make it clear that the CRSA, Carmel River Steelhead Association, has filed NOIs to be part of this discussion.
And Mr. Park, just for my record keeping and information, Carmel River Steelhead Association filed an NOI earlier this month to participate in this status conference.
Yes.
And I think I'm going to look to my team, because this is important. I want to make sure we have it on file, or that you file a follow-up. Do you happen to have in front of you the date on which you filed that NOI?
I don't. It's in an email situation, but
that's fair.
I give that to you. I worked through Mr. Schutz on this issue as well, and he was able to give us good direction, but I'm disappointed to hear that the NOI did not appear at your end.
Well, it's possible it was misfiled. So maybe one thing to do here would just simply to resend it to admin hrgoffice@waterboards.ca.gov. If you're able to identify either the original email and forward that to us, or just send us a copy of the NOI, or send us a copy of a new NOI, any of those would be fine, and we will look for that. And that would be helpful. I do want to make sure we have a clear record of that. Mr. Schutz.
Yes, I have I was served an NOI for Mr. Park on the 6th of June and for Mr. Leneve on the 7th. I would like to call to the hearing officer's attention the fact that the particular sort of generic email address that the State Water Board uses, admin hearing at so forth, sometimes rejects emails. And if I send anything to the State Water Board with those generic addresses through my normal email account, it is kicked back because somehow and I don't remember the name, the domain name is rewritten by some email processors. And so it doesn't show up. And this has been a long-standing issue for me. That's why I always send my personal communications to these board addresses through a Gmail account, because that one seems to get through.
Okay.
So it may be that there is a similar computer talking to computer issue with this. And I'd be glad to forward the, I'd have to forward it to my Gmail account and then to my, to you in order to show that this was served in the past. Otherwise, we'll try to resolve this. But I do want to call out to your attention that sometimes these communications are not delivered. And if there's anything that the AHO or the State Water Board can do to address that problem, it's pretty foundational and can have significant legal consequences as well as administrative ones. Thank you.
Thank you, Mr. Schutz. I absolutely agree. I mean, we have in the past had situations where an email went into what I'll call email purgatory, where it was it got caught in some filter and then we were never notified. I will certainly try to work with our IT staff to see if we can get to the bottom of this, or if we can think of another workaround. If we set up upload accounts, I mean, as you know, Mr. Schutz, from our other matters, once we have an upload accounts in place, then there's another way to submit documents. Although if we don't have an email, we don't necessarily see them in real time. But I agree with you, this is absolutely an important issue. If you're able to forward those emails to me, that may be helpful actually just for the technical aspect of this, because then we can send it to our IT staff and say, we didn't receive this, why not? What is going on? And that gives them something to focus on. A real example instead of a hypothetical gets more attention in my experience. So that would be quite helpful. And Mr. Lenev, I see your hand is raised, so please go ahead if you would like. And you are on mute. If click off mute so we can hear you, please. Thank you.
Oh, you can read lips. I did pull up my email and I looked at the, I don't know where I got the email list from, but I looked at the email list it went out to, and I don't see state water boards on that list. It went to 40 or so different people, but I don't see the email. So again, where I got that list from, it looks like the server list, but I don't see the state water board on that list. So no, I don't think you did get it.
Okay, and that's these things happen. So if you would please re-forward it to us, that would be much appreciated.
Chris, maybe we should work on that too.
Thank you. And thank you very much for communicating that. And we will do, if it turns out that it was sent to us and something happened, we will certainly follow up on that, because that is I agree, that's a potentially big problem. With that, is there anything else, please? Well, thank you. Once again, thank you very much for your professionalism and constructive work today. I appreciate it. We will be seeing each other soon. You will be seeing work product from me and additional requests, and I appreciate your attention to those requests. And we are adjourned for today. Thank you very much.
Thank you.
Thank you.
Thank you.